The long-awaited motion to dismiss was filed in the Karen Reed case just a couple of days ago, but it was not available to the public until today. And the reason for that is that they had to redact certain portions of the motion. We are not allowed to see some of the allegations that are made in that motion. Now, it seems to be that the parts that were redacted have to do with jury tampering or allegations of jury tampering or communications with the jurors or something that happened with the jurors getting dismissed from the case. So that seems what it has to do with, but we're not able to see much more into that. And we're going to see how that is actually dealt with by oral argument. Is that something that they're going to have to argue at sidebar? Is that something that Judge Cannone is going to order to turn off the live streams for? Who knows? But we can definitely talk about the other parts of this motion to dismiss. And we'll talk about the legal basis that they have or that they're citing that they have reason to dismiss this case. So it first starts with the sallyport videos. Now, like I said, I'm not going to be reading for you the entire motion. We're just going to be talking about the motion and the main parts the main arguments that they're making. So the first part that they're talking about is the sallyport video. The sallyport video, we already know the history of these videos. It really begins February 2nd, 2022. February 2nd, 2022, just 3 days after the murder of John O'Keefe, David Yannetti files an emergency motion to preserve all videos, photographs that have anything to do with the case. So that preservation order, that motion was granted. There was an order that was in the district court, Stoughton District Court, that was entered that the Commonwealth must preserve all of the videos as well as the metadata. Well, then you have the case was transferred to Norfolk Superior Court with Judge Cannone, and there was a motion to compel the discovery of those items, the video, the metadata, everything that was requested to be preserved previously. There was a motion to compel filed in September of 2022. Well, then October of 2022, Judge Cannone grants in part that motion and essentially orders the Commonwealth to produce those videos and the metadata. Well, this is October 2022. No videos were produced October. No videos produced November, December, January. For a full year, nothing was produced. The first time anything was produced was in April of 2024, right before the trial. And that's when they got their first video of the sallyport. Now, the video was not very good quality, couldn't make much out of it. But then in the middle of trial, they get another video from the Commonwealth. So obviously, the first red flag is what took 2 years to produce the first video when you had to preserve this from February 2022. What happened in between? That's the first red flag. And then you have another red flag that what's the second video all of a sudden being produced in the middle of trial? And that was the same video that was used for, that Lally used to question Buchanan on the stand and ask him about if it accurately depicts how the Lexus looked in the sallyport, and everything of that video is accurate, and truth be told, it was actually inverted. And he also testified that there was no law enforcement that went near the taillight. And really you can see that actually when the video is not inverted and it's actually looked at the right way, then you do see Trooper Proctor right there by the taillight. So that also was just another oops moment for the Commonwealth. So that was, again, another problem. Now then, what happens is that after the trial, there is another video that is produced, and that's the video that we see Brian Higgins on the phone at 1:30 in the morning at the Canton Police Department. Now, this is after he already testified that he did not make any phone calls that night. And he testified that it seems like a number of times that he did not make any phone calls that night, and any phone calls that happened that night were just butt dials. So then they got that evidence after the trial. It's another red flag. And then they get another video in January of 2025. And that video shows also the Lexus coming into the sallyport, but the video is very grainy and blurry, and you can't make much out of it. So isn't it a coincidence that this is what they argue in their motion? Isn't it a coincidence that every single video that they get in this case, for one reason or the next, you cannot see the taillight? And let's not also forget that in one of the other videos, I think it was in the inverted video, there's 45 minutes missing. The same 45 minutes that would have shown the Lexus coming into the sallyport. Isn't that a coincidence? So again, a lot of coincidences in this case that has to do with the sallyport. Now, another big problem that they argue about in this motion is the fact that none of the metadata, none of the logs about anybody touching this video, who touched one, there's no chain of custody. That's another problem with this video. So that is as it relates to the video. The second part of their motion deals with Jennifer McCabe. And Jennifer McCabe testified in her trial. And what we spoke about, that one of the rules of discovery in Massachusetts, for some reason, this is one of the few jurisdictions that has this, is that if you're the defense and you have impeachment material on the witnesses that the Commonwealth is going to call, if the Commonwealth requests, and there's an order entered into, which happened in this case, then you are required to turn over your impeachment material on their witnesses. Okay, so you have impeachment material on the Commonwealth's witnesses. You have to turn over that impeachment materials to the Commonwealth to let them know how you're going to impeach their witnesses. So the defense complied, and they turned over the data from Jennifer McCabe's phone, which showed that she actually made a stop on January 30th, 2022, at Sergeant Lank's house, the first responding officer to 34 Fairview. And that was something that was left out of any report before. So they were going to use that for impeachment on Jennifer McCabe. Well, now that they turned it over to the Commonwealth had a meeting with Jennifer McCabe. Now, they had a meeting, and around a week before she testified, she was called. She came down to the Lally's office, apparently, and they all met, including Lieutenant Tully. Now, at that meeting, it was very clear that this little piece of impeachment information came up, and they had to figure out what they're going to do with this, which is why during cross-examination, when Alan Jackson asked her, "Did you do anything else that day?" she casually threw in, "Oh yeah, we stopped by Michael Lang's house because Carrie Roberts, the daughter, such good friends," just very casually, nothing really to see here type of attitude. So that was prepared for when they met in the Canton Police Department, or wherever they met with Lally and McLaughlin and Lieutenant Tully, when they met with Jennifer McCabe on a week before she testified. Now, something else that they bring up in this motion is that when they had this meeting with Jennifer McCabe, that was a week before she testified. Now, if you are Lieutenant Tully in this case, and you have a witness who's sharing some more information that she never shared before, that would probably be a good time to write down and make a report about this additional information that you're getting. But that information he decided not to write down until after Jennifer McCabe testified. So the defense didn't get that information until June. They didn't get this report that was not authored until May 29th of 2024. So this meeting happened May 10th. And then about 19 days later was when Lieutenant Tully decided, it'd probably be a good idea to document and write down what Jennifer McCabe just told me about her stopping off the next day at Michael Lang's house. And that's when he wrote it down, May 29th, when it was already, Jennifer McCabe already testified at that point. So that's when they got the report like June 4th or something. So that's one issue. Now, they also bring up the issue that the Commonwealth is required to turn over statements by their witnesses. The same way that we know those emails, it was such a big deal about the ARCA experts, those emails back and forth between Alan Jackson and Wolf that you had to turn over. You got to turn over these statements and these emails. That's part of Rule 14 obligations. Well, what about this statement that Jennifer McCabe made on May 10th before she testified? Well, it was never documented. They never wrote it down. So maybe that's why just conveniently they didn't document it and there's nothing to turn over. Well, again, part of this motion is that they argue that doesn't have to be that documented. Any statement that was made should be told to the defense. Either way, it's suspect that Lieutenant Tully decided to wait 20 days before documenting what Jennifer McCabe said and completely changed her version of the events. So that was another issue that they bring up as well. So you've got Jennifer McCabe, you've got the sallyport videos. So where does the basis for a dismissal come from? Well, there's 4 different bases that they argue for in this motion. The first basis is a Brady violation, right? Brady violation is that the the Commonwealth is required to turn over exculpatory information. That's pretty basic. Everybody knows that when you have exculpatory evidence and you're the Commonwealth, you're the prosecutor, you're required to turn that over. So therefore, they were required this entire time to turn over the sallyport video. And if they're going to say that every 30 days it overwrites itself, which is very clear that they've kind of cemented that as their argument in this case, well, then that means that they must have had the sallyport video already within 30 days of January 29, 2022. So what took 2 years to turn it over to the defense? What was going on with it at that time? And remember that there was some case law that we spoke about. They didn't cite this case law, but there was some case law that we spoke about in a previous video about whether you can trust copies or not. Can the Commonwealth say, look, I mean, these are the copies of the videos where at least now we're turning everything over. But the case law said, and we explained this in the previous videos, the case law was pretty clear that that's okay unless you can have questions about the authenticity of the copies. So copies, you don't always have to turn over the originals. If the copy is just as good as the original, then you don't have to turn over the original. But if you have reason to doubt that these copies are not as authentic as the originals, which in this case, it seems to be clear that there are definitely some questions about these copies of the videos with people appearing all of a sudden out of nowhere and skips in the videos, and there's no chain of custody and no logs, and there can definitely be a reason why you actually need the originals. So when it comes to Brady, that's going to play into the argument as well. So they argue, number one, is that these videos were not turned over. They're Brady material, and we don't know if anybody manipulated these videos or changed or altered these videos. And that's why, number one, based on Brady, they should be able to get this case dismissed. So let's talk about that just in terms of the Brady argument. In terms of the Brady argument, the way that Brady works, right, is that we want the trial to be fair. And therefore, if you're not turning over certain exculpatory evidence, then it's not a fair trial. So what happened in the Alec Baldwin case, for example? Well, the question was, where did the ammunition come from? How did the live ammunition get onto set? So the whole case of Alec Baldwin was that this inexperienced armorer, Hannah Goody Ayers-Reed, was the one who brought this this live ammunition onto the set. And it was her fault. And it was all because Alec Baldwin didn't supervise or whatever. There were some arguments there that Alec Baldwin didn't act safely either. But if the ammunition did not come from Hannah Goody Ayers-Reed, well, then it could be somebody else was trying to sabotage the set. And that was part of the defense. Well, it turned out that there was some ammunition that's possible that was turned over to the police that did not originate from Hannah Goody Ayers-Reed. And that was buried, in Alex Spiro's words. So that was exculpatory. And this only came out in the middle of a trial. So in the middle of the trial, this information came out. So that's a Brady violation, and therefore the judge dismissed the case. So what do we have here? Do we have a similar situation over here? Well, you can definitely have the argument if you're in the middle of a trial or if you're right before a first trial. Here, though, the problem is that what everyone's been talking about is that we are before the second trial. We have a new trial now. Second trial. Maybe the first trial you could have had a Brady violation. Yeah, maybe so. But if you have a second trial coming up, as long as the second trial is going to be fair, then all of the courts want the case to be adjudicated by the merits. They don't want to dismiss cases for Brady violations. If they're able to get all the material over, if they're able to get all the exculpatory evidence over to the defense, so then the courts do not like to dismiss cases based on Brady. So therefore, when it comes to all these videos, if the Commonwealth can actually argue legitimately and credibly that these are all the videos that we have, and now you're right, there were some silly reasons why they were not turned over. Maybe there were some violations, and even though there is like part of Brady is that you have a duty to preserve it even without any sort of orders. So even if you ignore all the Rule 14s, ignore all the court orders that were entered into for this preservation of evidence, Lally has a duty on his own. The prosecution has a duty on their own. The Commonwealth has a duty on their own to preserve exculpatory evidence, even not being asked to. That's required. So that's number one, that they were required to do that. But if they're able to argue, the Commonwealth's able to argue that, look, now we corrected everything. Now you have all the videos. Guaranteed. You have all the videos that we ever had. then, what's the argument there? That, well, okay, now you have the videos, and just there's nothing exculpatory, or there may be whatever exculpatory information you have now. You have Brian Higgins on the phone now. Okay, great. Now you can use that in the second trial, so it'll be a fair trial, right? So that's an argument that they can make, but it doesn't work for one piece of information, and that is the metadata. The metadata is lost. It seems to be that metadata is unrecoverable. And the reason why it's unrecoverable is because the download was not done in a forensically sound way to preserve the metadata and to preserve the logs. So those logs, that's number one. The logs are gone, never to be recovered ever again. And the metadata is gone. So all of this information is exculpatory, definitely possibly exculpatory, and it was not preserved. So that's Brady material that there is no way to remedy at this point. The Commonwealth does not have any way to do it unless the Commonwealth can figure out some way to get the metadata. They can go back now and somehow magically they can get the metadata, or they can get the logs. Then they say, okay, look, we're turning everything over now. You're right. We should have turned it over before. Our fault, our bad. But you know what? Now we have a new trial. So that's where I see the issue in terms of the Brady violation coming up to the second trial, that there is certain information that is not going to be available, and it's exculpatory, and it's not available because of the Commonwealth's failure to preserve it and to abide by their court rules and to abide by the orders of the judge, court orders. So that is argument about the Brady violation. Let's move on to the next argument. The next argument they make is that there's a Rule 14 sanction. So Brady has nothing to do with Rule 14, really. Brady is a requirement on prosecutors regardless of any sort of rules of discovery. Rule 14 is a specific discovery rule. It's a criminal procedure rule in Massachusetts, which requires the prosecution to turn over certain materials, which would include these videos. And definitely when there is a motion that was brought under Rule 14 for this material, and that also they have this Rule 14 obligation to turn over the materials. Now, something that was amended March 1st, 2025, is there's going to be new rules of criminal procedure. And actually, this actually helps the defense because the new rules that go into effect March 1st, 2025 say specifically that one of the remedies, one of the sanctions for a violation of Rule 14 is dismissal. So therefore, they're arguing again. Number two, the second legal basis that they should be able to dismiss this case is because there's a discovery violation under Rule 14 that they did not provide the videos. Now, again, the videos themselves, if the Commonwealth can argue that, look, we're providing them now, then the sanction of dismissal is not going to be granted. But if there's some sort of materials that are not available because they're gone, and the Commonwealth had a duty to produce them under Rule 14, well, then what is an appropriate remedy? The only appropriate remedy in that case is dismissal, because this is information that is discovery that was required to turn over. The Commonwealth had a duty to get it and do the due diligence and make sure that they're able to get a forensically sound copy of that information, of that video, and they didn't. So that's a Rule 14. That's Rule 14 violation, which cannot be remedied. So, for example, let's take the ARCA experts. Let's say there's an argument that there's a Rule 14 violation when it came to the ARCA experts. They did not turn over these emails. Okay, now you turn them over. And now we have a second trial. This is what part of Robert Alessi was arguing. We have a second trial coming up. The judge, you said that this is a second trial. It's a new trial. Well, if it's a new trial, then great. Here's the information. Now you have all your Rule 14 disclosures. You have your Rule 14 discovery. So you're right, we violated it. Maybe give us a sanction. But now that you have the materials, so now there's no reason why our ARCA experts cannot testify. Well, in this case, when it comes to the sallyport videos, you can't quite say that because this data doesn't exist anymore. The metadata doesn't exist. The logs don't exist. And it was because the prosecution, the Commonwealth, did not preserve them properly. They did not follow the Rule 14 obligations. They violated Rule 14. And so there's no other way around it. There's no other way to produce it all of a sudden now and say, okay, well, now it's going to be a fair trial. So that's when it comes to Rule 14. So you have Brady, that's one legal basis. Number two is you have Rule 14, that there's a discovery violation. In Rule 14 itself, it provides for a sanction, which is dismissal. And even if there's not explicitly in the rules, there definitely is in the case law that a Rule 14 violation could rise to dismissal. And this would be a textbook case where there's exculpatory evidence that was not preserved because of failure of Rule 14 or because of violation of Rule 14. So that would also be a reason for dismissal. That's number 2 argument. There's a third argument. The third argument here is that there's a court order. When you violate a court order, you can also have a sanction. Okay, so there's a sanction for Brady, there's a sanction for violating Rule 14, and then there's a separate sanction for violating a court order. So if a court decides to order anything it wants, court puts in an order, you have to show up to court on this and this date and this time. If you don't show up, you can get sanctioned. So this happens in many times. They'll subpoena someone to come to court, the person won't show up, you'll file a motion, show cause, order, then that person can get sanctioned. And definitely if you're a party to a lawsuit, you can definitely get, or a party to a case, you can definitely get sanctioned. So here the question is, okay, so what's the appropriate sanction here? What's the court order? Well, here the court order has to do with turning over the videos and the metadata associated with those videos and the call logs. So aside from it being a Rule 14 obligation, aside from being a Brady obligation, there's also a specific court order which required the prosecution to preserve and produce that metadata. And there's case law that says if you violate a court order, then dismissal, you can rise to a level of dismissal. So that's a third basis why this case should be dismissed. And this is all coming from the defense's motion. Finally, the fourth argument that they make that this case should be dismissed is because there's a sanction for prosecutorial misconduct. They also call it governmental misconduct. And that is when a prosecutor is not prosecuting a case appropriately. It's egregious. And they're intentionally doing things which are not appropriate. So that's another basis for prosecutorial, for a dismissal, for prosecutorial governmental misconduct. So in this case, they're saying it seems like there's a lot of misconduct here. There's intentionally misleading a jury. There's intentionally trying to tell a jury that your witness is, that this video is accurate, which is not inverted, and that you're eliciting in testimony which is false, that no one ever went near the back of the right of the right taillight when people did. And you've got this collaboration with Jennifer McCabe, and then reports are not being written about it till 20 days later after the testimony. This is, and then again, there's not listening to court orders, not following Rule 14 obligations and Brady violations. Well, then that also tells you that there's some prosecutorial misconduct. And one of the quotations to the case law there about when to, what type of sanction you should give is if this is conduct that can be repeated. Is there some sort of pattern here? Is there some sort of practice here? Person does something wrong once or makes a mistake or makes a silly mistake. Okay, let's not call that prosecutorial misconduct. But once you start to see a pattern, you start to see videos that are just not produced for 4 years, 3 years, and then all of a sudden they're being produced. And you see this type of shenanigans in this case, inverted videos. And you're seeing what's going on with Jennifer McCabe, and then these reports not coming out till later. This all looks like one collusion of misconduct. Looks like everyone's in on this together, trying to make sure that the defense doesn't get certain information at certain times. So as furious as you can be against the defense for hiding this communication with the ARCA experts, well, you can definitely have the same type of animus against the Commonwealth when it comes to this type of information that was not turned over. And certain things that seem to be hidden. So that's another basis that they're arguing for the dismissal here. So that is the 4 different legal bases why they're arguing that this case should be dismissed. And it comes down to really the sallyport videos, the metadata, and what was going on with Jennifer McCabe and that video and the testimony and the late report and not giving over the statements of that impeachment material, and as well as the last basis which was the jury tampering or the juror dismissal there, what was going on with that situation, which we don't really know so well about right now. So that's really the rundown of what this motion is all about. We still have to see what the Commonwealth responds. It's not crazy to believe that there should be some sort of evidentiary hearing about this. That's what happened kind of in the Alec Baldwin case. Have an evidentiary hearing. Have people come up and start talking about why there's no call log. How was this video downloaded? What did you do in order to preserve this video? There was a court order here. What did you do, Adam Liley? What did McLaughlin do? What did you do in response to trying to perform your obligations? So it's not unreasonable to believe that there should be some sort of evidentiary hearing. Now, whether Judge Cannone is going to grant it or not so sure. But from these allegations and from these, and this is going to be uncontested. I don't think that the Commonwealth is not going to, I don't think they're going to be able to contest that they turned over videos late. They did turn over the videos late. They're not going to be able to contest that the video wasn't inverted. It was. And this report that was written by Lieutenant Tully was written on May 29th. That's when it was written. That's the date on it. It's uncontested. And in there, it says that the meeting happened May 10th. So, just fill in the dates here. You got Jennifer McCabe testifying May 17th. So this is all clear. It's not like the Commonwealth's going to contest that part. Now, of course, they'll make arguments that everyone, was completely fine and nobody did anything wrong. And then anything that did happen was just a mistake or something like that. I'm sure they'll make arguments like that. But to really get to the bottom of this, you'll probably need an evidentiary hearing. Now, again, is Judge Cannone going to grant that? Not so sure. But I don't think it's unreasonable to believe that that's what should happen here. So that's going to be it for today. That's basically the motion to dismiss in a nutshell without reading the entire 36 pages. And sure, it's available out there if you want to read the entire 36 pages, but that's really the rundown of the summary of what it is. So that's going to be it for now. If you haven't yet, please subscribe, like, and we will see you next time.